In one particular case, the parents included the elder son's name on the property titles but willed the assets to the other son. The surviving joint owner refused to relinquish the properties. So what steps can you take to prevent such disputes? In Singapore, joint property ownership disputes are common, particularly when a child is named as a joint owner. Still, the parent intends to share the property amongst all the children. Understanding how joint ownership works and planning accordingly can help you prevent such conflicts. When a property is jointly owned, the surviving joint owner automatically inherits the entire property upon the other owner's death. This can override the intentions stated in a will. In one particular case, the parents included the elder son's name on the property titles but willed the assets to the other son. The surviving joint owner refused to relinquish the properties, and the siblings sued and won because the elder son knew his parents did not intend to give him both properties. In another case, a man and his daughter were joint owners of an HDB flat. The daughter became the sole owner upon his death, despite the father's will stating that the flat should go to his son. The court ruled in favor of the son due to sufficient evidence of the father's intentions. So what steps can you take to prevent such disputes? Number 1, use a power of attorney. Suppose parents want their children to help manage their property. In that case, they should use and set up a power of attorney instead of naming them as joint owners. This legal arrangement allows children to act on behalf of their parents without being co-owners. Number 2, giving shares in properties. Parents can add a child as a tenant in common, giving them a share of the property. This prevents the child from inheriting the entire property upon the parent's death, as the remaining shares will be distributed according to the will. Number 3, be transparent in your arrangements. If a parent wants to add a child as a joint owner but does not intend for them to be the sole owner, this must be recorded explicitly. State the purpose of the arrangement in a will or a specific document and have the new joint owners sign an acknowledgement of their role for administrative convenience only. Being transparent with intentions, such as sending an explanatory email to beneficiaries, can also serve as helpful evidence in disputes. Here are 3 practical tips that you can take away from this case. Number 1, document everything clearly. Ensure all intentions and arrangements are documented in legal documents, wills, and specific agreements. Number 2, communicate with family members. Discuss plans with all beneficiaries to ensure everyone understands the intentions and reasons behind any arrangement. Keep beneficiaries informed about any changes in the arrangements or intentions. Number 3, seek professional advice if possible. Consult with legal professionals to ensure all arrangements are legally binding and reflect your true intentions. Proper planning and clear documentation are essential to prevent disputes over property ownership. Using tools such as powers of attorney, tenant in common arrangements, and transparent communication can help you ensure that your assets are distributed according to your wishes and reduce the likelihood of family conflicts. If you found this helpful, follow and subscribe to our channel for more legal things.